So we have an important update in the Vanderstock ATF frames and receivers case. The ATF has now filed for Supreme Court review, and the Supreme Court is now set to consider this case on Friday. So let's talk about what is happening. Now, before we jump into this video, I want to thank the sponsor of this video, which is Delete Me. Delete Me is a company with a very simple mission. That mission is essentially to help you to control what information of yours is out on the internet. Delete Me does this by targeting large data brokers. Data brokers are simply corporations that collect huge amounts of your personal information. This includes information like social security numbers, birthdays, past and recent addresses, information about your relatives, and a lot of other information that you might not want out there. I personally use Delete Me to get rid of some of my personal information that was floating around on the internet. And this is very important to me because although I am, obviously a forward-facing figure here in the 2A community, I still want some sort of privacy, and I don't want my information out there and my family's information out there, and Delete Me helped me to get rid of that information. So if you want to take control of your own personal information, I highly recommend that you check out Delete Me. You can find them using the link down below. And if you sign up using the code SCHOLAR, you can get 20% off of that membership. So thank you again to Delete Me for sponsoring this video, and check them out if you want to take control of your private information. As I mentioned in the intro, in this video, we're going to be discussing an important development in the ATF frames and receivers case called Vanderstock versus Garland. The ATF has now filed for Supreme Court review in this frames and receivers case, and the case has been set for Supreme Court conference, and it's happening this Friday. Maybe by the time you're watching this, the Supreme Court would have already gotten together and considered this issue. The pro-2A side has responded by saying yes, they agree with the ATF that the Supreme Court should take up this case immediately. However, they agree with the Fifth Circuit that this ATF rule is invalid and must be struck down. The government has followed up with their recent brief stating that all the parties agree that the Supreme Court should grant review in this case, and therefore when they hold conference on Friday, April 19th, the Supreme Court should actually agree to take this case up. This critical review is happening because the Fifth Circuit recently handed down its decision on the summary and final judgment of this case. The Fifth Circuit panel recently decided and partially upheld a lower court ruling, but also vacated it partially because the Fifth Circuit believed a vacatur of the entire rule nationwide was beyond what the lower court's power was and what they could do. I predicted that after losing at the Fifth Circuit level, the ATF would decide to bypass the Fifth Circuit en banc panel and just simply go directly to the Supreme Court, and that's what they did. Now, the ATF is hoping that the recent 5-4 emergency stays that the Supreme Court issued in their favor in this case will lead to a favorable decision on the merits. But in my opinion, that's a mistake, and a huge mistake, that the ATF is making. They're just assuming that the Supreme Court will still rule in their favor on the merits. Now, to understand what is at stake with this case and why the Supreme Court's hands in some ways will be forced to at least hold this case, we need to talk about what has happened prior in this lawsuit. Originally in this case, the original plaintiffs, FPC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule while the case made its way through the process. On review, Judge O'Connor granted a limited preliminary injunction against the ATF, which prevented the ATF from enforcing their rule against Tactical Machining and its customers. After the preliminary injunction stage, the plaintiffs sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor did grant the motion for summary judgment, and the relief he granted was vacating the frames and receivers rule in its entirety nationwide. That was a huge win because the judge struck down the entire rule as invalid and found that the ATF could not enforce it at all nationwide. Well, of course, the ATF did not like that, so they appealed the summary judgment up to the Fifth Circuit. Then the ATF sought a stay from the court, from the lower court and from the Fifth Circuit, to halt the nationwide vacatur at least while the appeal was going on. However, both the lower court Judge O'Connor and the Fifth Circuit denied that stay request. That then led the ATF to go to the Supreme Court on an emergency application on an interlocutory emergency basis for the first time. They asked the Supreme Court to issue an emergency stay, which prevented the nationwide vacatur issued by Judge O'Connor from going into full effect. And in a 5-4 order, the Supreme Court agreed to stay the enforcement of the summary judgment decision, which vacated the rule nationwide. In that 5-4 stay order, Justice Barrett and Justice Roberts joined the liberals and decided to essentially rule in favor of the ATF and put a block on that nationwide vacatur. Through that order, the Supreme Court stayed the nationwide vacatur until the Fifth Circuit could review and rule on the merits of the case. Well, after the Supreme Court issued that 5-4 emergency stay order, 80% Arms and then other companies like Defense Distributed went back down to the lower court judge, Judge O'Connor, and sought an emergency motion for a new preliminary injunction. They asked for Judge O'Connor to put back in place his prior preliminary injunction that simply just protected the company and their customers. Essentially, they just wanted the same protections that were in place before the nationwide vacatur. On review, Judge O'Connor agreed and granted those limited preliminary injunctions. Of course, the ATF again did not like that. They argued that Judge O'Connor was directly defying what the Supreme Court said in that recent 5-4 emergency order. The Fifth Circuit disagreed, did not give the ATF their stay, and then that led the ATF to go to the Supreme Court for the second time on an emergency basis. And for the second time, the Supreme Court sided with the ATF once again and struck down even the limited injunctions. So the Supreme Court prevented a positive relief in this case twice, and ultimately led to the application where no positive, either limited injunction or nationwide injunction, could be issued in this case. And it pretty much just streamlined this entire process to have to go to the Supreme Court, for the Supreme Court to have to rule on something for there to be any actual true relief in this case. Now, the Fifth Circuit was still reviewing this case, was still reviewing the merits. Ultimately, the Fifth Circuit did rule on the merits of this case, and the panel partially upheld what the lower court did, and then they also struck down the ATF's rule. However, the Fifth Circuit 3-judge panel found that they believed an outright vacatur of the rule nationwide was beyond what the lower court could do, and it swept too broadly. Therefore, they partially upheld what the lower court said as far as the actual merits of the decision, but sent it back down for a more limited type of relief. Now, really, that all ties into what the Supreme Court has said and has continued to say, that they are pretty much against lower courts, federal district court judges, or even state judges issuing nationwide forms of relief or universal forms of reliefs, especially at preliminary injunction stages and then other types of relief as well. Now, despite the type of relief which is being debated, the ATF still lost this case. They have still lost the merits of this case. The rule is going to be struck down. Now the question is, what type of relief will be granted? Will it be more limited, or will it be a little bit more expansive? The ATF, of course, does not want to lose on the merits, and that has led them to have to file an actual writ of cert to the United States Supreme Court. The ATF filed their petition to the Supreme Court, and they are arguing that the Supreme Court should strike down what the lower court said, and not only just strike down the nationwide vacatur of the frames and receivers rule, but also they should rule that the ATF did engage in lawful rulemaking, and that this restriction on unfinished frames and receivers and the whole rule process was indeed proper. FBC and the plaintiffs have now filed their response to the Supreme Court and are saying essentially that they agree with the ATF that the Supreme Court should review this case. But of course, they disagree with the ATF's position that this is a lawful rule. In their petition, the FBC states in their response that respondents agree with the government on the proper disposition of the government's petition for a writ of cert. This court should grant the government's petition to determine once and for all whether ATF's rule expanding the definition of firearm to include weapon parts kits and items that with additional manufacturing could become frames and receivers is consistent with the definition of firearm in the Gun Control Act. ATF's rule inflicts irreparable harm on respondents and other industry members every day that it remains in effect, and respondents accordingly agree that this court should determine the validity of the rule now, instead of potentially waiting until after remedial proceedings conclude in the lower courts. In response, the ATF has filed their final brief, and it's simply a 6-page response. The ATF refutes the position taken by the organizations, and they again claim that the Fifth Circuit and the lower court judges, the lower court Judge O'Connor, simply got this analysis wrong. However, they point out again that both sides agree that this case is ripe for Supreme Court review, and the court should take up this issue now. The Supreme Court conference for the Vanderstock case has now been set and will take place this Friday on April 19th. Now, if you're not familiar, Supreme Court conference is when the Supreme Court gets together and votes on whether they intend or want to actually take up a case or deny cert, which simply means that they're going to deny review to the case. Typically, all it takes is 4 judges on the panel on the entire Supreme Court to want to grant review to a case. So it only takes 4 judges who say, yes, we should review this case, that this has, a merits issue that we want to review, and this is a case that we should grant review to. I think this case, at the very least, will be held until the court ultimately rules in the Cargill bump stock case, and maybe after that would be GVR'd by the Supreme Court. But I think this case, Vanderstock, the fact that it's already been up the Supreme Court twice, there's been emergency motions twice on this, emergency orders by the Supreme Court. And I think this is an issue that maybe the Supreme Court would be a little bit more interested in. And also the fact that they are pretty much limiting any type of positive relief happening in this case until they intervene means that the Supreme Court pretty much has to intervene in some way. Conference, again, this week, very important, especially for a lot of these companies. It's very important for companies like 80% Arms and others. And then we're going to wait to see what happens next week. And we're going to be keeping our eyes on the order list of the Supreme Court, hoping that they have granted review to a new ATF case. So if anything changes, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.